Today, we're going to present a pretty wide overview of a lot of asset protection and associated tax work. And we'll finish the seminar with an overview of what's being called the Inflation Reduction Act. It's a lot of information, and we're really going to try to hit mostly the high points so that you at least get a takeaway of the salient issues. In terms of the topics, they actually take up 2 slides. We're going to get into the basics on some asset protection. That's your standard columns of asset protection, trusts, and how it's the taxation of trusts, both domestic and international, but basically how we move from doing our domestic asset protection using LLCs and trusts and exempt assets to how also we implement a similar structure offshore and how that works tax-wise. We'll then have an overview of expatriation, which has become kind of a major issue now in light of the fact that expatriation really applies to long-term residents of the country. Even if you're not a citizen, these expatriation tax can be very relevant to you. And then people coming in, what would you really need to do coming in to avoid a lot of the US tax? We call that pre-immigration planning. And then we'll go through this Inflation Reduction Act. It's fairly limited in terms of, I know we have a lot of CPAs on the webinar. It's fairly limited in terms of your practice because it's really applicable to public companies. But some of the provisions will impact a lot of the planning and certain compliance and tax avoidance strategies. So with that, we can start on the first section of the webinar, which is your basic asset protection. I'm going to probably go pretty quickly through some of these slides. We have a lot of slides, but the basics and asset protection is not hiding assets. It's basically where you're looking at existing law and structures to use to the best protection, to provide the best protection for your situation possible. Everyone's a little bit different. We're all involved in different professions. We have different wealth. We have different risk tolerances. And so the idea is that essentially everyone should create a structure whereby if you become part of a litigation, you don't lose what you have just from some accusation or because you've gotten caught up in a bad investment or you have some type of event and liability event. It's not hiding. Hiding doesn't work at all. The basics of asset protection are essentially titling, which means, well, how do I purchase an asset? Not an asset that's not available to creditors. That's what's called an exempt asset. So if we have life insurance from an asset protection standpoint, depending on the state, the life insurance, the homestead, they're exempt assets. They're not available in litigation. So if we have something else that is exposed in litigation, we have to title it properly. And it's unbelievable. Pretty much every week people come into the office from people from, very modest backgrounds to people who, we have a number of billionaires that we work with and haven't properly titled the assets. So if in fact they have a judgment that, they want to fight, or they feel like, oh my God, I could actually become subject to a creditor, they have unnecessarily exposed these assets. So titling, for example, would be tenancy by the entirety is a big one in Florida. If you have 2 spouses, they can hold things by the entireties, which is kind of a legal fiction. We call that a legal fiction because you have 2 people and they can hold the asset together. But what that does is allows them to insulate the assets from the claims against one spouse. So if there's litigation or a judgment against one spouse and the asset is properly held by the entireties, it's not available. It's not available to the creditor. It's very simple, very direct, and is combined with other strategies very, very easily, very easily. So that's an example of titling. There's more complexity to it. For instance, with tenancy by the entirety, there's entireties. You actually have to be married. The assets have to be part of the marriage. For instance, if wife comes into a marriage with a bank account, and then there's a wedding, wife adds husband to the bank account and says, oh, okay, we're going to put tenancy by the entireties because that's a protective title. It's not by the entireties. That's not an asset that is part of the marriage. That's its own seminar, but just to keep in mind, there are rules you have to follow with respect to this titling. Exemptions, I had mentioned, principally people are aware of the insurance exemption. So depending on the state, that exemption will apply to the insured. In other words, if someone sues the insured, if the insured is the owner, that asset is not available in Florida. Proceeds are also exempt in different states in different ways. So you have to be careful with insurance. One good way to avoid all of the complexity is to put insurance into an insurance trust, which is the next basic column of asset protection. So trusts, and we'll get into some detail on trust, domestic and foreign trusts, but trusts are basically placing assets with a trustee for someone else. That's the standard trust. So in the 1500s, someone in England would go off to war and place assets, because women could not hold title, in trust with a trusted advisor, a friend, a family member for the kids. And that's a trust. And what it did was it created an exemption, an exempt asset in a sense, because when assets are placed in trust, the trustee holds legal title, which means the trustee can invest and move the asset around in the trust. But the trustee cannot benefit from trust assets. So it's a legal title to sign to move those trust assets around or manage the trust assets. And then the beneficiary has beneficial title to trust assets. So if assets come out or benefit anyone, they have to benefit the beneficiary. But the beneficiary can't make management decisions. So what happens is you divide, unlike by tenancy, for instance, where we talked about bringing them together, you divide title. And with a divided title, if someone, for instance, sues the beneficiary, hey, you've got 10 million in trust, you're the beneficiary. If the trust monies come out or benefit anyone, they're going to benefit you. So we want that. No, you can't get that, because the beneficiary doesn't have legal title to those assets. The beneficiary cannot move assets out of the trust to the creditor. And that creates the trust fund baby and all of the controversy associated with that. But that works well. It's worked well for 500 years, has not been overturned. We'll talk about some of the exotic trusts that have come into play in the last essentially 25 years. But the trusts are still a very viable option. And as an aside, create an exemption to tax in the future. Years ago, that was lobbied into the Internal Revenue Code, where if assets are added to trusts for beneficiaries, for family members, for instance, those assets pass from generation to generation without tax. So if you hold assets in your own name and you move them to the next generation, they are subject to estate tax if you're above the exempt amount. If they're in trust, they're not. It's kind of a little known issue. It's a massive issue if you have a taxable estate, but we have people come in all the time with 20, 30, $40 million that have not properly planned. You can plan with that much, but it becomes harder because now you're talking about a substantial gift tax. And then we talk about, as the fourth column, we talk about entities, sometimes business entities, LLCs. We typically combine the LLC maybe under a trust. We use the titling of LLCs for tenancy by the entirety. We'll get into how LLCs can be weakened, but they are a great vehicle for certain searches, situations. With respect to LLCs, basically that was an evolution. Corporations, for instance, have what is known as inside liability protection. So things inside the operation of a business. So if you start a corporation and you operate the business, right, the business liabilities do not become liabilities of the owner. And in Florida, it's very strong. Depending on the state, that inside protection, hey, it's a business liability. It's not my problem. I'm just an owner. And it varies from state to state. In Florida, it's very strong. So that's inside asset protection. We start a business, and if we fail, we fail. The suppliers, the creditors cannot get to the owners unless they've guaranteed some kind of debt. Now, outside asset protection is if someone sues an owner, can they get to the equity? Can they get to the shares? Can they get to the LLC interest? Well, corporations don't offer outside asset protection. So if someone sues an owner, they can take the shares. That's why you have these shareholders agreements, which create a buyout right. If someone gets sued and their shares become in jeopardy, the other partners can buy the shares. But that isn't necessarily a great remedy. A lot of times those shareholders agreements unfairly treat either the seller or the buyer and create a lot of unintended consequences and shifts in ownership that really were never intended. There's other exposures too we have listed here with respect to the misuse of the entities. We don't really come across that much, but you can't use your corporation or LLC as your personal piggy bank. It becomes kind of worthless. So on the outside asset protection, where someone can take corporate stock, that's where the LLC comes in. It originated from the partnership law. Partnerships basically expose the original partnerships, to the liabilities of the partnership. So no one really wanted to form a partnership, because if something happens inside the partnership, everybody's liable. It's like a disaster. But they did have outside asset protection. So if someone sued a partner, they couldn't get in. They could lien the interest. They could put a lien on that partnership interest, but they could not get into partnership assets. So there was a period of time where we had this LL put on partnerships and this LL put on limited partnerships. That's this LLP and LLP. And that limited the liability of the partners with respect to business operations. That was a precursor to LLCs that kind of become pretty much archaic in light of the LLC. So the LLC basically says you get your inside asset protection. What happens in the business doesn't affect the owners. And it also provides the outside asset protection. So what happens to an owner, in other words, an owner has a car accident or a bad investment, and there's a creditor and they want that LLC interest, and they can't take it. They can just lien the interest. It doesn't affect the other partners. It doesn't affect the assets of the LLC. That's the general rule. There's some other advantages to the LLC we have here, with respect to, you don't have all of these rules associated with how corporations have to keep minutes and bylaws, etc. That's great in the fact that the LLC is a lot more flexible. It's not great if you don't have counsel. So what happens is people start drafting their own operating agreements and creating their own rules, and then when something goes wrong, they end up with kind of a scattered, unintelligible situation, which creates litigation. I tell people when they don't want to do an operating agreement that we also do litigation. Anyway, formation, yeah. So this is more of the same. relaxed formalities. It's very easy to form them, and they do create the limited liability inside and the outside asset protection. The question then becomes, where do we form the LLC? What is this idea of exposure to the single member LLC? How do we choose a jurisdiction, and what is offshore? What do the offshore LLCs offer? We try to stay away from these jurisdictions that follow the revised Uniform Limited Liability Company Act. In a nutshell, we want an LLC that offers the charging order protection. The charging order is that lien. So when someone sues a member, all they get is a lien. If the LLC makes a distribution out, the lien holder could be paid. But the revised act, there's a committee that creates uniform acts, and they do all kinds of different acts, for all different areas of law. And the revised act it usually creates, if it's adopted by a state, would create a fairly weak LLC. So we tend to stay away from those, and basically, even in some jurisdictions, it allows someone to sue an LLC owner and foreclose on the equity and actually become a member, which is the last thing you really want when you form an LLC. It all comes down a lot of times to this internal affairs doctrine. The internal affairs doctrine says that in our state, we create a statute that includes a respect of the internal affairs of other state statutes. So Florida has that statute. A number of states have a statute. Some states have cases. And the question then becomes, well, what's an internal affair? So if I form a Delaware LLC, which says single member LLCs are protected, we'll get into that, but it's kind of a major controversy. So single members are protected. Florida says single members aren't necessarily protected. So if someone in Florida creates a Delaware LLC, and we've adopted the internal affairs doctrine, in general, is the LLC statutory protection in Delaware, is that an internal affair? Because if it is an internal affair, then if someone forms an LLC in Delaware, in Florida, from Florida, right, forms a Delaware LLC, funds the Delaware LLC, that LLC statute, which protects a single member, would apply. I think this pretty much is completely ignored, but technically that's kind of what's supposed to happen. The cases are pretty much all over the place. Some of the issues that are impacted by the internal affairs doctrine are on this slide. The inside transfers, the statute of limitation, the charging order, which I mentioned. So related to that, the voidable transaction acts are different in each state. In other words, that's when someone has a creditor and they're running away from the creditor to fund an LLC for protection. The creditor can then pull back the asset out of the LLC. Not a great idea. The different states have very different voidable transactions act, actually. And so is that an internal affair? Do we respect that? Or do we just follow our, in Florida, internal, uniform fraudulent transfer act? A couple of cases are enlightening. The cases, you have to keep in mind, usually involve some kind of maniac that's taking all their assets and throwing it into this and throwing it into that, and then they get to court. But at least we can see how the courts react to the maniac. It gives us some window as to how they'll react to people in regular civil litigation context, right? In Wells Fargo versus Barber, you had Sabrina Barber, who defaulted on, I think it was 65 or $67 million of real estate debt, and then started to fund all kinds of stuff all over the place. So she funded a Delaware bank account. She funded a Nevis LLC after the fact. So it was clearly what we call a fraudulent transfer, where someone's trying to react to a creditor and fund what they would consider protective entities, so to speak. And the court had a lot of options. The court could have said, I thought the court was going to say, well, she's in Florida. She's actually, it was an Orlando and Miami combo case. The assets were in Florida. I thought the court was going to say, well, our fraudulent transfer act applies. So the assets are here. I'm just going to lock them down and give them to Wells Fargo. I thought that was kind of an easy answer. That's not what the court did. The court said a number of things, but in terms of our issue, well, you funded a Nevis LLC. Now, the Nevis LLC, I was involved in the drafting of that LLC, has tremendous protective language in it with respect to fraudulent transfers, with respect to the charging order, all kinds of stuff. Of course, she left all the assets here. So the court says, amazingly, my partner and I were debating this, my litigation partner. And I was like, well, they're just going to do fraudulent transfer. My partner actually said, no, they're going to do something with that. They're going to do something with that LLC. I was like, why? So the court says, no, she's here. The assets are here. We're going to call it a Florida LLC. It's not a Florida LLC, but we're going to treat it like a Florida LLC. And in Florida, it's not protected. So we're just going to disband all the assets and give them to Wells Fargo. I was shocked at the court's decision, but that's what happened. So if we go and we look at that in terms of the next few cases, we realize that where you file suit as the plaintiff is very instrumental. So she was in Florida. Florida does not protect the single member LLC. And that's a fairly new idea in Florida. And that's kind of the wave, like, let's break into these LLCs. Whereas this JP Morgan versus McClure case was an Arizona litigation. The LLC that was to be broken into was in Colorado. But the plaintiff that won the judgment in Arizona went to Colorado to collect. Probably there were assets in Colorado besides the LLC. So they go to Colorado. Now, this idea of crossing state lines to figure out what law applies, the judges don't need to do that. So the judge in Colorado, which protects the single member LLC, says, no, we're going to apply Colorado law, and we find that the LLC is protected. And our own internal affairs, even though the judgments in Arizona will apply. So where you go, it's fairly significant, because the judges tend to apply their own law. They don't really want, there's nothing illegal about it. A lot of people think if I go to Florida, they're going to apply Florida law. There's nothing illegal about the Florida court applying a law from another state. Venue and law are different. But you have to be careful, because when you go to that state, they're probably going to apply their own law. One really poignant example of that is this Arroyos v. Ellis, where you had a litigation in the state of Maine, which involved a Delaware LLC, and they wanted to crack into the Delaware LLC. And the plaintiff brought the case to Alabama. I think the plaintiff was from Alabama, if I recall right. So the plaintiff brings a case to Alabama, Maine litigation, Delaware LLC. The court says, you know what, this is great. I'm in Alabama. I'm not even going to look at the matter. You need to go to the jurisdiction where the LLC was formed. Is that correct? I don't see why it's correct, but wow, is that debtor friendly? Wow, is that debtor friendly? If anyone takes that into consideration as precedent, the court actually sent the litigants to Delaware to figure it out. In this state, on this slide, we kind of go through, well, which state court is correct? I think that the internal affairs doctrine should be respected. I also think that the fraudulent transfer doctrine should be respected. So when you have these cases where someone does use a protective entity, but they're doing it to escape from a creditor, I think the fraudulent transfer act comes into play, whatever state it is, and those assets can be taken back out of the protective LLC. At this point, we really don't know what's going to happen. There's another line of cases that talk about stocks and stock certificates and LLC certificates called the Sargent case. And in that case in Florida, the court said, well, you have won the judgment, but you've got to take that judgment to Dominican Republic and United Arab Emirates to collect it, because that's where the stock is. And then now we have a new case that says, no, it's not a Florida Supreme Court case or a US Supreme Court. And it says, no, you don't have to go there. You can take jurisdiction over the person. And if the person doesn't bring those stock certificates back for collection, you can put them in jail for contempt. So now we have conflict in Florida. And I think really based on that later case, that Shim case, that's probably going to govern all of the litigation people. And that was a higher court too. All of the litigation people think that if you have jurisdiction over the person and the judge makes an order, the judge can force the person to comply through civil contempt. Now, we've had a lot of civil contempt cases where they put them in jail, but they don't give up the stock. And let's just say people will sit in jail for a while and end up keeping the stock or the assets. There are cases where people won't, but you can sit in jail. They can't keep you in jail forever on civil contempt. It's an interesting topic. It's really more academic mostly. So now we move to the single member LLC. And after a court sits in trial and goes through 2 years of civil litigation, and then there's a judgment, the courts really aren't looking for someone to say, well, that's nice, but I've got an asset protection plan and you can't get anything. So one of the ways that we see the courts tapping into the LLC, and this happened essentially through bankruptcy, which allows the judge much more collection power, was with a movie star, Ashley Albright. She had single member LLCs in Colorado bankruptcy court. And the court said, we're going to go ahead and take the old English doctrine that applied to partnerships. Remember, partnerships also allow for the charging order, that you can only get a lien on the interest of a partnership, someone's interest in the partnership if they become subject to a judgment. And if you're not more than one member, you can't be a partnership. So we're going to throw out the charging lien for LLCs. Had pretty much zero reference to partnerships or this multi-member in the LLC statutes. It just says you can't get it. It's only available for lien. But the bankruptcy court did a workaround through looking at the partnership law and exposed single member LLCs. Several states, Delaware, Nevada, for instance, it basically went back into their statute and says, no, it's okay. Even if you're single member, the only thing you can get is a charging lien. And Florida did not go that way. Florida had the Olmstead case. I'm not sure. Here it is. The Olmstead case, which resulted, it was a long process, but basically resulted in the exposure of the single member LLC in Florida. So essentially, you want to avoid single member status in Florida. You'd have to use an LLC formed in one of those jurisdictions that respects the single member LLC. If you operate in Florida, is it going to work? We don't know. It should work, but we don't know what the courts are really going to do. Here's some of the banter on Olmstead and Albright. You basically have to use multi-member now. How do you create another member? Sometimes on these single individuals, well, we use nieces and nephews and trusts. Is that going to work? Well, we don't know if that's going to work. Is it going to work if you own 99% and the trust owns 1%? Well, California says no. Essentially, California says no. So California had this case. I want to make sure I cover everything here. So California had this case called Kershey v. Baldwin. And we could do a seminar on this case. It's a very interesting case, actually. So you had a very wealthy developer, Baldwin, was sued on a relatively small matter for Baldwin, a $5.5 million loan. Kirchie won the case. So Baldwin owed the money. And California had a line of cases with respect to corporations where this idea of taking stock in a corporation, the idea was you can get what's called outside, you're piercing the veil from the outside. The court said in the prior cases, well, there's no piercing the veil from the outside. Well, of course, there's no piercing the veil from the outside of a corporation because there's no outside protection. So they went through all of these cases, and basically what happened was Baldwin created this very elaborate family holding structure, which was completely done without any thought. And he basically controlled everything and kept the 99%. I am extrapolating, by the way, but kept a 99% interest in these variety of family entities and gave the wife 1%. And they kind of went through an analysis whereby, that may not be two members. It may not be two members. And the court didn't rule in that regard. It hasn't come back yet, but that was the issue. Whether or not in California, under those circumstances, that the plaintiff judgment holder could actually break the charging order and get into the company. And they said, yes, it's possible, and sent it back to the trial court. It's a kind of a very interesting case. It's not really a bad actor, this Baldwin, but Baldwin was very flippant with the court and really didn't do a very good job at all defending the matter, in my opinion, from what I could see. It was a Delaware LLC too. So in Delaware says even if you're a single member, so you had a 99-1, is that a single member, really? It's protected. But there was no discussion of Delaware law. And I was curious, I haven't read this deeply into Kirchie, but I was curious if that defense was raised. I didn't see, I read the case, but I haven't seen, sometimes you can look at the pleadings and stuff. Anyway, that idea of this reverse veil piercing where you could take a piece of an LLC, even though the statute only allows you to lien that, has been upheld in other jurisdictions as well. And this is one click. And I had mentioned, well, how do we create other members? We can create trust for the kids, relatives, etc. But I wouldn't do 1% now. I think that door has been opened. Offshore, the key to offshore planning in general, both the LLCs and the trusts, is that the assets are offshore. So if you're not going to keep assets offshore, oftentimes it's really not that helpful to use an offshore entity. It's more exotic. The courts are more skeptical with respect to the offshore planning. But if the assets are offshore, it's very, it can be very, very protective. So we drafted a statute in Nevis for the LLC, and those protections, those standard, charging order protections, the statute of limitations on fraudulent transfer, a lot of these items were made even more powerful. But as we saw in Barber, if we keep our assets here or we do fraudulent transfer, it's not going to help. The idea is you would have assets offshore in this LLC. This LLC itself may even be held by a foreign trust. When we have single people and they don't want to add anyone, we can't use TBE, because with TBE, we can always, even if we don't want to include the kids, we can always put the LLC, if we're worried about the two spouses being viewed as one owner. That ruling has not been made. But if the two spouses have been made as one owner, we get another protection. We get the TBE. In TBE, the plaintiff has to have a judgment against both husband and wife. So you want the TBE on top of the LLC. With unmarried single people who don't want to add people or who want to avoid the charging order, right? They can't do TBE. We have a self-settled trust, which is allowed in 18 states now. We'll go into some more detail on that. So we can make our own trust, which says if someone sues you, they can't get into the trust. So instead of getting saddled with a charging lien, you may be able to avoid it with a self-settled trust as a single individual. Here's the trust section of the webinar. We just wanted to go through some of the main pieces. Irrevocable trusts are really the only protective trusts. Revocable trusts, because they can be changed at any time, are not protective at all. We have people in the office at least twice a month come in with a revocable trust package, basically a will, thinking many times they've been told it's protective. It does not offer any protection. If you can change the trust, it's not protective. Where you form the trust is very, very important. Obviously, we have those 18 states in the US that allow you to create your own protective trusts. The cases are mixed on those trusts, but if you're single, in many cases, what's the harm? I mean, if there's a likelihood that they're going to be protected, you might as well use it because it's probably going to be protected. There's a chance that it wouldn't be protected, but we have defended several of those. So you have 18 states domestically that use that. A lot of times we use foreign trusts for foreign assets. If someone's, for instance, we have a lot of business sales, we do a lot of mergers and acquisitions work. You sign an indemnity if you sell your business. It could be between 2 and 4 years. Well, the indemnity can be substantial. If your buyer comes in and mismanages the entire business, they're going to probably sue you, whether you deserve it or not, for the purchase price back. And we recommend on some of these large transfers that several $1 million be placed in an offshore trust, because if that's done properly, it's very, very hard to break into that trust. Some of the reasons we don't do it domestically are if you can see on the slide, are the full faith and credit clause of the US Constitution. Basically says if I have a judgment in one state, I can register it in another state, and that second state has to respect the judgment. Now, we've defended Nevada trusts against that, but that doesn't happen offshore. No one cares if you have a US judgment and it's not applicable to your offshore trust. But in the States, you have that relationship, which you avoid with an offshore trust. This is the asset protection trust we talked about, where you make your own trust, and only 18 states allow it. Nevada, Alaska was the first. We like Nevada. We like the statute a lot. Florida does not allow it. It's somewhat untested. Bankruptcy court does not like it. We had a case here in Reuber where someone formed an Alaska self-settled trust for themselves, but they left all of their assets in Washington State. The co-trustee was in Washington State. All the kids were in Washington State. Everything was Washington State. And they filed bankruptcy. Bankruptcy basically allows the judge to make a public policy ruling. And public policy, who knows what that means at this point. It used to be public policy was, if you killed yourself, you couldn't collect on your life insurance. Now it's just, if I'm in the mood and you don't seem like you're from Alaska, we're going to break into your trust. So don't file bankruptcy. Your protections are not going to be respected. And it's basically true in light of the fact that you're asking for something from the court. You're asking for a discharge of indebtedness. And in exchange, the court's not going to be very lenient on you in terms of your asset protection. Mortensen was an interesting one, which also involved bankruptcy. This mountain man created his own asset protection trust in Alaska. He apparently followed the rules and it was okay. And he was from Alaska and his assets were in Alaska, but you have to be careful with their bankruptcy. So he was kind of all set from what I could tell in the case. And then he was outside the statute of limitations on this divorce issue where the wife could claim, whoa, that's a fraudulent transfer. He's just going to get a divorce. I need to get to those assets. Well, it would have been too late. He filed bankruptcy, which extended the statute of limitations for 10 years and lost the assets. Kind of a crazy case. Trustco, the Trustco case, the takeaway from the Trustco case, you have a Florida litigation with a Delaware asset protection trust. And the plaintiff that actually got the judgment in Florida filed in Delaware. Remember, we talked about you don't want to file as the plaintiff in a protective jurisdiction. So they filed, but they had waited 4 years after the transfer, and the court just threw it out. Once the 4 years pass, you can't file for fraudulent transfer. The statute of limitations is over. The takeaway from the case is that the defendant, the borrower, notified the bank, okay, we're doing some planning now and we're going to move assets into a protective structure. And now you know, because now that you know, the statute of limitations runs. Otherwise, it's always a year from the time they know. This is a slide on some of the technicalities. You don't want to create your own asset protection trust. I mean, very few people do, but if you miss a piece of it, the court will never respect it. Also, you don't want to retain ridiculous control over these trusts, or it just looks like you've done nothing. That's the sham trust. They won't be upheld. You want to segregate. It's the same LLC planning where you have like a number of properties. You want to segregate those properties and LLCs under the trust. You can do it without having to file a lot of tax returns if it's done properly. Here are some of the advantages, some of these protective aspects of foreign trusts. This is a little bit older, this chart, but it gives you an idea of what we added to the LLC and what's been added to some of these protective jurisdictions. I wanted to get through in the last 10, 15 minutes some of the keys. A lot of these, which we had mentioned, are foreign trusts where assets were left in the States, or they're self-settled trusts that aren't properly funded. This Rush Medical is a very interesting. I had mentioned already the Sargent case, and that's Sabrina Barber. This Rush Medical was an estate. So dad said to the hospital, look, you're in my will, you can rely on it, you can start the new wing of the hospital, you're going to get the money. But the money slipped into foreign trusts. And either that money, this is the way it works in general, either that money in the foreign trust or other monies of the estate were still exposed. So the hospital says, we started this wing, like we relied on this money, you got to give us the money. And so the court said, no, the hospital relied. That was an obligation of the estate. So if you're not going to give up the money that's in the trust, we're going to take other money out of the estate. You're not going to be able to make any distributions out of that probate. And so the hospital won. And apparently there's a new case, I haven't read it yet. There's a new case that has a similar outcome in Illinois. This is the alter ego again. You just want to make it real. You want to create a trustee that's independent. You want to follow the LLC formalities. You want your operating agreement. You want to issue shares. You want to make sure distributions are pursuant to proportions. All of this stuff is real when it comes to litigation, or else you look like what's called alter ego, which you're just the trust, you're just the LLC. It's just a sham. That's all of this stuff. And you want to create, if it's a trust, this is the effectiveness. You want to create a connection between the locale of the trust. We've actually had clients buy condos in Nevada to create a connection. And, where's the account? Where's the trustee to that jurisdiction? The courts have mentioned that. And I think if you have a substantial connection to, we do a lot of Nevada work, they'll probably uphold it. Let's run through taxation. Some of the big issues on taxation are kind of the differences between foreigners or foreign trusts and U.S. people and trusts. We now, for U.S. residents, that's a resident of the U.S. or a citizen of the U.S., we have a humongous exemption. So you have $12,060,000 per individual, $12,060,000 per individual, and you double that to almost, about 25 million for a couple. So you have to have more than that to have an estate tax issue. We have a number of clients that have more than that, but but for terms of a public issue, it's become kind of a minor issue. Years ago, it was 600,000. A lot of people have more than 600,000. For someone who's not a resident or a citizen, we only look at U.S. assets, but we don't have the exemption. We just have the $60,000 exemption, um, which is very minor if people buy property here, especially. This 16,000, that's your annual exemption, by the way. It's not that significant. It's the same as the credit in some sense, but you don't have to file a gift tax return if you give less than 16,000 a year. This is some background, and we can give you as much background, even the outline to this if you want. We're just not going to have time to do like these full seminars on the tax side of asset protection. They're really different seminars. We just want to give you a flavor. We want to expose you to some of this. Domestic trusts are treated as domestic, pretty much domestic individuals. Beneficiaries are taxed on distribution. Foreign trusts are treated as foreign individuals. On the income tax side, if you're a citizen or a resident, you're taxed worldwide on all the income that you make. Worldwide. So a lot of people living here don't realize that, the 3 million they make in Brazil is taxed by the US, and there's no treaty. There's no treaty, double taxation treaty. You don't have to pay tax on to both countries, but you typically have to pay the higher, and it's usually not a perfect credit. So you owe tax to the US on all that foreign income. On the estate tax side, oh, by the way, you're a resident under substantial presence. So if you're here more than half the year, or if there's in the last 3 years, if you're here, the cocktail party rule is more than 120 days. So you don't want to stay more than 120 days for income tax. On estate, if you come here and want to stay here, I know that sounds interesting. Want to stay here. What does that mean? It has to do with intent. Do you intend to stay? If you intend to stay, then you're a resident and you're taxed on the estate tax worldwide. You're a US person. Non-US people on the income tax side are just taxed on US income. There are exceptions. If there's a treaty between the two countries, you may not have to pay tax on US income. If you have essentially capital gains, if you sell stock in the US, you're not taxed. Very, very few people know or understand that. The foreigners know it, but the people in the US don't realize that if a foreigner buys IBM stock and sells it, there's no tax. It's a 30% withholding. It's a flat rate. A lot of people talk about the flat tax. It's a flat tax. So you make income from the US, interest, rents, it's a flat rate. There's some elections you can make. If you have a lot of property, you can be treated as a US person and take deductions. But basically, it's a flat rate. The foreign trust is treated as a foreign person. On the estate tax, I had mentioned worldwide, if you're a resident. If you're not but you get the huge exemption. If you're not a resident, you're taxed on your US assets. You can give away intangibles. So if you have stock in companies, you can freely give them away. If you're a non-resident, non-citizen, no tax. But if you die with them, they're taxed. So you've got to be very careful with that in terms of the gift versus the estate. And then, without going into massive detail, because I think we're going to end up running out of time, foreign trusts are treated as foreign. If you're a US individual and you have a foreign trust, the reporting is fairly onerous. It's fairly onerous. It's much, much more detail and description from you, the trustees, all the beneficiaries regarding the foreign trusts. Here's again a reiteration of how non-resident aliens are taxed with respect to the estate. What's a foreign trust? Well, a foreign trust fails one of either the court test or the control test. Can a US court control the trust? is the trustee, the one who manages the trust, are they bound by a U.S. court? If either of those is not true, it's a foreign trust, and then you have this onerous reporting requirements. What happens with to take away the major issue is if you're a U.S. individual and you move assets, you kind of export assets to a foreign trust, and you have U.S. beneficiaries. Almost always there's U.S. beneficiaries. It's considered what's called a grantor trust. This is an income tax issue. Because it's grantor, this section 684 doesn't apply until the death of the grantor. So if the assets go offshore, the general rule is they're taxed as if they're sold. But if you have U.S. beneficiaries, the tax is deferred until death. So you got to be very careful. When the grantor dies, all of those assets are taxed as if they're sold that day. Not the estate tax, the income tax. But if those assets, when they went out to the foreign trust, were not a complete gift, were not gifted out of the estate, they get a step up in value. So you don't have a gain. You have to be very careful with that gain issue on death. The same is true for foreign individuals. We're talking again about treaties. Treaties can wildly reduce your income and estate tax rates. But what I wanted to mention was for foreign individuals, they'll come in and we're going to go through what happens if they funded a foreign trust. It's the same idea. Expatriation, to get you to the takeaways before I go over on my time, is you basically have individuals who would, for the idea that you can sell stock in the US with no tax, right? Created a lot of offshore investment, still does really. But you had people, entrepreneurs, who would create a business here. And the business, they knew the business, right? They were already in the business, and they created a big business here, and they knew who to sell it to internationally. But they would leave the country and become a non-resident, non-citizen. And they'd sell the business, no tax. They'd sell the stock. Well, that couldn't, basically Bill Clinton in the late 90s said that's got to stop. And he needed to generate some income for the tax coffers. Killed foreign investment, but at the moment, that was the move. And so what had happened was you had this section 877A implemented. So if someone would leave the states, they had to wait 10 years to sell to get the tax-free treatment. But what happened was that wasn't working because people were waiting the 10 years, or they would operate the business outside the country, etc. And we implemented in 2008 the exit tax and the inheritance tax, which we show on this slide. So the exit tax basically became the day that you exit the country, everything you own worldwide is treated as if it were sold. And if there's gain, you got to pay the gain. It's a debacle. People focus on the expatriation side of it, but the real impact is on the non-resident alien that's here 8 years under a green card. Many people come in, they start a business, or they create substantial assets here and abroad. They don't realize it's abroad too. And when they leave, they give up the green card. By the way, they leave because they don't want to suffer worldwide income taxation, right? So they leave, they give up the green card, but bam, that day it's a deemed sale of all their assets. That's the exit tax in a nutshell. There are a lot of strategies to deal with that to try to get you under $2 million. There's an exemption amount of about 700,000, but very wealthy people can't deal with that. So it takes a while to plan for this exit. Here are your exemptions here for minimum income, and you have a $2 million threshold. So you can give things away, et cetera, to get under $2 million if you're not that wealthy. Again, there's an exemption amount. You also have to file the right tax documents, or the expatriation will not take effect. Interesting, the mirrored tax for estates is a reaction to the idea that if you move abroad, if you give up your green card and you leave, you become a non-resident alien, and a non-resident alien can buy and sell property outside the country, can buy and sell intangibles, can give away intangibles, can give away assets outside the country. So what they did is they imposed an inheritance tax on the grantee. So if you give assets to a US person after you leave, you can't do it tax-free if they're foreign assets or they're exempt assets, otherwise exempt assets, intangibles by a non-resident alien. You're not treated that way. That person that you give the money to owes the tax. It's a tough tax. This is the inheritance tax. It's a 40% rate on the grantee. The typical gift on the state is not on the grantee. It's actually on the grantor. And you have some reporting here. You can do all kinds of different strategies to get your net worth down, like gift to trust, etc. This is how you mitigate it. On the pre-immigration planning side, basically, you want to get assets out of the estate. So what you do before you come into the country is you get all the assets down so that when you come in, you don't bring them into the estate tax net. And the way you do that, here's again reiterating the income and estate tax, is typically you form a foreign trust, right? And as a non-resident, you fund the foreign trust, your assets worldwide aren't taxed by the US, and you get them out of your state. But you got to be careful, because there's a rule that says, here's your strategies, okay? There's a rule that says, if you formed a foreign trust and you come in within 5 years, we're going to treat you as if you formed and funded that foreign trust the day you come in. So you get back into this idea of expatriation of assets. You've gotten those assets out of the estate, so they won't get a step up at death, but you've gotten them out. So the idea is, once you're here and everything's settled and out of your state, when you're comfortable, you domesticate the trust. And that's not a taxable transaction. And you're done. You've gotten everything out. That's how it works. Here's an overview of the foreign trusts, and they're basically treated as foreign persons. This is the grantor rule where you can get assets out, and then when you die, it's taxed, but if they're part of your estate, it's not subject to tax. Let me finish up with a little overview I've got like 1 minute left. I'll go over a little bit. This is this Inflation Reduction Act. Fortunately, there's not a lot here, especially we have a lot of practitioners on the line. With respect to your day-to-day practice, it involves two things, essentially two taxes. One is a 1% tax on stock repurchases. It's for public companies. That's not that significant, except to your practice. It could be significant to a public company, but it's in terms of, you got to be careful, because we do a lot of mergers and acquisitions, and those reorganizations can often involve a repurchase. It might get caught by that 1% tax. Just be careful of that. The other side of the Inflation Reduction Act is this AMT, alternative minimum tax. It's not broad-based. It's for public companies with $1 billion in revenue. So you're talking about actually about 150 companies. That's it, right? You still have to be a little careful with it if you represent these companies. If you do, one huge issue, which I found, there's a lot of exceptions to it with respect to smaller companies and the rest of it, but it doesn't really apply to the smaller company, is the GILTI tax. We do a lot of GILTI tax work, which can be brought down to 10.5%. GILTI tax is a minimum tax on income earned abroad if you have a controlled foreign corporation. This could change it. The way it's drafted, it changes it. Whether they're going to enforce it like that, we don't know, because it doesn't go into effect until 23. But it actually, because it's a minimum tax, it raises the GILTI tax. So we'll see the way that all works. Just be aware of that. In terms of it reinstates the super fund on the basically on the oil spills, etc. It funds the IRS pretty significantly. This huge IRS deal that everyone's talking about, this is the funding mechanism. Be careful. You've got a focus by the IRS on captive and crypto. They've already focused on easements. You should see some of these offerings. I'm looking at some of these offerings now. The easement offerings are like, we're now blacklisted. Don't, it's every possible warranty and representation that you shouldn't do this when they're selling these easements now. It's kind of funny. And the crypto is a disaster because they can't follow a blockchain. They don't know what to do in terms of enforcement on this crypto, so they're focusing on it. And the clean energy. That it's going to fund that. In other words, you're going to get all these credits now, all this solar, you see all these panels going up all over the place because it's going to fund the credits. It's going to do drug prices. It's going to afford the Affordable Care Act. And in terms of integration into the planning, I had mentioned the redemptions and the GILTI tax. On a lot of these investments you're going to hold in these structures, look for a combined add-on for green energy. You got the clients buying these huge green energy. Look for that because they're going to get incredible credits. And can you combine that with this new opportunity zone issue where you actually have an opportunity zone where they don't pay capital gains tax at the end of 10 years, combined with the credits? It's like the old PIG. You're just buying credits and tax capital gains avoidance. So I think I've crammed at least a 500-page treatise into an hour. I hope you enjoyed that. I hope it was entertaining. If you want more information or want to speak to us, or you want copies of my books on international tax or asset protection, we've got my contact information here. And thanks so much for attending.